Welcome to the Nitty Gritty Law School. The Nitty Gritty Law School was started by a fellow by the name of Bob Foster. And he recorded Roger Elvick's material, and he also sold stuff relating to trust. So I managed to stumble across him and bought some of the Roger Elvick tapes from him, and he then died of a heart attack a little while later. And his wife had asked me if I'd be willing to answer questions from people who had bought his tapes. And I said, sure, I'd be happy to. But I needed a hotline to Roger Elvick so that if I got stuck on something, I'd be able to get answers. So she arranged that, and I managed to get involved with about 150 cases. A lot of tragedy along the way. A lot of people paid a big price for their effort. Some people had some luck, but we worked out a lot of concepts. We made our mistakes, and we continue to make our mistakes, but at least we're improving and refining this. And so here we are. Now the Nitty Gritty Law School is not a school, provides no certificates. I guess at best I could classify myself as the court jester. Okay? But I do share some information with you. And today we are going to concentrate on form. Now in the past we always concentrated on substance. What is a court? What is a sovereign? What's the relationship? And so forth. And all that information is delivered on other recordings relating to sovereignty. In this case, we're going to deal with form. How do you put a lawsuit together? What do you put on the page, and where do you put it on the page? So that's the basic thrust of what we're doing today. So I guess the first step is to get serious, so I will. As the sovereign of the court, I specify what the rules are. Okay? And if you're sovereign in your court, you say what the rules are. However, there's an important principle, and that is that you have to communicate with court personnel. You've got to communicate with the judges, particularly with the judges, with the opposing attorneys, if they're willing to communicate with. A lot of them know everything, so it's hard to tell them anymore. And but you have to communicate. Well, the best way to communicate is to speak the language of the listener. There's a lot of people who put together lawsuits, and you've seen them probably. They've got giant letters, inch and a half high on their papers. They have all sorts of claims. They want the support of Yahweh and that sort of thing. But I view the court process as being very secular, down to earth. And I deal with the real world rather than the spiritual world. Okay? And it's important that when you put together your paperwork, that you follow the customs. In one sense, you're the king, you're the sovereign. You can lay out all the rules. You can set the rules of court. You can set the laws that you're charging with. And of course, the jury will sit in judgment of your law and discount it if necessary, if in their opinion, they don't like it. So you have that as the great limiter on your arbitrariness. I think I've explained in the past how I really get torqued out over pink shoes in my presence, and so anybody who wears pink shoes in my presence is going to suffer the death penalty, and because that's important to me. When I charge somebody with violating my law, that defendant has a right to call on a jury, and one of the big limiting factors, now it doesn't mean I'm admitting I'm wrong, but one of the great limiting factors is that it's really tough to find a jury that will support my law. And so far I've had no convictions. Now on the other hand, if I also have another law which says that I have a right to walk down the street unmolested, provided that I'm not bothering anyone else. I'm simply walking along the sidewalk. So if somebody comes from behind and knocks me down and breaks a bone, and I come back and charge him with assault, my law against assault, and my penalty is 30 days in the Huskow, the probability is that I would find a jury that would support that. I think I could get a conviction on that one if I had that law, no assault, that's unprovoked, and 30 days in jail. So the common law, again, is basically public opinion. And you have to, if you do have a case, whether you're right or wrong in your own point of view, if you do have a case and you run it through the court system, you have to remember that you have no physical power. Okay? You can have all the law on your side, but if everybody's against you, then you do not have the physical means to enforce it. We have no guns. We have no control of the paychecks. So all we can do is win our cases and then rely on the very people that sometimes we're in conflict with, rely on them to enforce it. Just to kind of review a little bit of the concept here, because it leads into where we're going, it's very important that you have to speak the right language. Language is important. You have to learn the legal language. Now, is that in focus for everybody? Everybody can see it okay? Close? Let's see if I can improve this just a shade. Mo better? Anyhow, so you have to speak the right language, and in this case the language is English, legal English. Okay? You all know business English, or formal English, it's also known as. You all know how to speak slang, when a lady who's wearing a cool outfit comes in and you let her know it's a really hot outfit. It's also important to know what a court is. And a court basically is a stage upon which the sovereign conducts his show so as to satisfy the rest of the world that his decision is a good one. See, when you're the sovereign and you bring someone in, you're the sovereign plaintiff, you already know he's guilty. Okay? Otherwise you wouldn't be bringing him in. And he already knows what he did. He either knows he's innocent or he knows he's guilty but lies and says he's innocent. But either way, what goes on between you and the defendant, there's nothing that either one of you can say really to each other that you don't know already. So why have a court? Well, the reason is because you want to convince the rest of the world. This is a stage. And that's the number one rule. That is the rule in all capital letters. Okay? Never mind the legal definition of a court. The real purpose of the court is to put on a show. And you want to make it a good show. And who is it that you're putting the show on for? Who is this rest of the world? Well, it's the judges, the lawyers, the sheriffs, the jury, the clerk, the jury. Right. That's who you're putting the show on. Well, these people come in with all levels of education, all levels of ignorance, all levels of arrogance, all levels of compassion. You got everything there. So you've got to get through their shells, particularly of the people who are not on your side. You've got to get through to them. And so how do you get through to them? Well, you speak their language. And so that's what we have. We have this language here, as I said in the beginning, and then you also have the court. And now you're going to put that language in the court into your paperwork. And that's what we're here for today, is the form of the paperwork. Now, a lot of people place a lot of importance on form. Now, the general rule of thumb, the legal maxim is that form is superseded by substance. That's the general rule. But the fact is, when you look at the courts and how they operate, when the government courts, you'll find that they put form ahead of substance. So we have to have good form when we go in there. So, as a starter, Let's go down to procedure. And specifically, I want to talk about court papers. Whenever you want something from the court, you write a letter to it. Now, when you write a business letter, there's a format that you're familiar with. You put your return address and date on the upper right-hand corner, and then on the left side you put the name and address of who the letter is to, and then you say, "Dear Sir," or "Dear Madam," or whatever, and then you go into the body of the letter, and then you have the signature block. That's the form you use when you write a letter that's formal to another person or a business. When you write a letter to the court, they don't call them letters, they give them a different name, but it's really what you're doing. So the first letter you write to a court is called a complaint, or it's called an action. And you can write other letters to the court, those are called motions. Or if you're on the defending side, you write a letter to the court saying that, hey, the other guy's wrong, and here's my point of view. So basically, to accomplish this, you have basically what you do is the very first thing, you take your claim, which is item number 2 on this list. You take your claim for damages to the court and the clerk, and you also take your facts. You also have a brief. In the brief you discuss what the law is, you discuss what the facts are, and you discuss what how this all connects together. And then you also then get from the clerk a summons. And you take that summons, you package it with the claim and the facts and the brief, and you deliver it. And then after you've got it delivered, and it has to be delivered by somebody other than yourself, somebody who has no stake in the outcome of the case. Since you have a stake in the outcome of the case, you're not trustworthy in that respect. The court wants to be somebody that's what they say is arm's length. In other words, somebody over whom you have no control. And that person serves it and files a paper with the court, files his own little letter, which is called a proof of service, where he tells the court, okay, I did deliver this is how I delivered it, this is who I delivered it to, and so on. Then as part of this package, you also have the proposed judgment, which is usually called a prayer. At the end of your complaint, you have this thing called a prayer, which is prayer. All it is you're just saying to the court that based on all this other information, I want you to give me whatever it is you're asking for, X dollars in damages, or an ordering the other person to do something or stop doing something. But that vacate the planet. Yeah.
For the bar association.
Yeah, for the bar association, right. But the thing is that understand that this stuff it has its complexities, it's true, but really there's nothing magical about papers, the court papers. You're basically writing a letter. You're putting down your point of view. However, there are certain ways that they do things. But that's your very first paper that goes into court is the complaint has these elements. After you're in court, you have more papers, but they tend to conform to this format up here. You basically have a notice of a motion, okay, where you give the other person a notice. Well, that's kind of like the summons. You notice really the same things are there, but they change the names, part of their formality. You have a motion, you have certain facts, which you put in by affidavit or declaration. You have a brief, and the brief contains the points and authorities, which basically means that you have the point being made, the authority that supports it. In other words, you quote laws or whatever. And then the argument in support of your point. And then you have to serve it on the other person, and you have a proof of service. That way the court knows who got a copy. And then, and along as you're doing that, you also throw in a proposed order, like the prayer in the complaint. For a motion, you have the proposed court order. And by the way, the attorneys are normally prohibited from putting in proposed orders. If you ever receive a motion that the opposition is making and the attorney is putting in a proposed order, right there is a rule violation, at least in the federal courts. I'm not sure about the state courts, but I think it applies to states as well. But in the federal courts, there is a rule violation. The rules say very specifically that an attorney may not submit an order. Okay? The reason why? Well, I think it's because as an individual, you're in your sovereign capacity. You speak for yourself. The actual order is a little too personal, I guess. I really don't know, but that's my suspicion. It's just that the attorney is actually an agent. He's a representative. In theory, the agent's supposed to know as much as the principal, but in actual fact, he has no business influencing the court in that way. Now, once the court makes a decision, often the court will instruct the winning side to type up the order. Okay? Now, if that ever happens to you, read that order carefully, because it may be that when he does type it up, he throws in an item or two. Okay? In which case, you should object to that order. And a proper judge would say, yeah, that wasn't in my original order, and scratch that part. And judges get very informal, by the way, in how they do things. When they modify the order, they just scratch it out with freehand and write in what they want. Okay, well anyhow, that's just kind of a brief overview. Let's go into an action at law. This is kind of an example. Okay? The first thing is I want to cover the elements. Now, this is going to get a little complicated here. So, you've got to pay attention. If you fall asleep, you'll miss something. Okay. Basically, here's how the system works. You start off with, well, actually, this isn't how the system works. I want to apprise you. I'm not going to really go into this, but I want to apprise you of another paper here that precedes all of this. It's called a notice and demand. You see, right here, notice and demand. When somebody is stepping on your toe, frankly, you don't know if he's doing it on purpose or if it was an accident. Now, it's the nature of our legal system that if it's an accident, there's no responsibility. You know, a perfect example of this is, let's say you're driving down the road, you're doing 25 miles an hour in a 35-mile zone. Okay, you're 10 miles under the speed limit. And out from between some parked cars, a child runs out, and you can't stop, and you strike and kill the child. In our system of law, you are not held responsible for that. That was an accident, beyond your control. Now let me tell you something, that isn't how it works in all systems. In fact, I read of a case one time where this man, of course he was an American in Saudi Arabia, okay, that might have had something to do with it. He's subject to Islamic law in Saudi Arabia. And what he did, there was a curve where the road curved, and off to one side of the curve there was a parking lot. And he got a little volume there. So he parked his car in the parking lot and went into the building. A Saudi Arabian came zooming around the curve, was going too fast, went off the curb, over the parking lot, hit the car, and I think he was killed. I'm not sure. It was a bad accident. So they charged the owner of the parked car, made him responsible for this, because they said that he had free will. And he had decided to park there, and had he not parked there, this wouldn't happen. Okay? And under Islamic law, he was responsible for the death of this person. Okay? Or the injuries, anyway. So you see, this is this concept that we have of not being held responsible when it's a genuine accident is rather unique to the English world, the English-speaking world. But that is actually unique to the Christian world, because now in Mexico, my understanding is that you have an accident, automatically everybody's arrested. All the witnesses are arrested, everybody's arrested, throw them all in jail. We'll sort it out later. Okay? There's no concept. The exception to that is if you're holding Mexican insurance. Okay? The Mexican insurance companies have made arrangements with the government, apparently. So, in this country, you are not held responsible for something that was purely accidental. So if somebody is stepping on your toe, you don't know if it's an accident or not. So you got to find out. So what you do is you send this person who's standing on your toe a notice and demand. You say, hey, you're stepping on my toe. If he turns back and he says, yeah, what of it? Well, now you have a case. Okay? Now you've established that you gave him the notice and he continues to do it. So there are 8 things that you need to do in a notice and demand. First of all, you have to tell him what he's doing, because maybe he doesn't know. Okay? And then you tell him what the injury is that's happening to you. Okay? It might be your loss of substantive rights, but somehow you're being injured by his actions, or you're being injured by his lack of action. Could work that way too. Okay? He has a duty to not cause you an injury. Okay? So you bring out the moral, public, and private laws that require him to not cause you the injury. So I think is it one of the Title 42 sections, I forget which section it is, that holds a person responsible for failure to acting. Yeah, I'm not sure which one it is, but it's somewhere in there. It might be 1986 or something. But whatever it is, I think it's one of those sections. It's either Title 18 or Title 42. 241, 242 for Title 18, and 1983, 85, and 1986 for the Title 42. But basically, you cite the moral, public, and private measurements of the damages. Now, a good way to figure out what the damages are is to look at the fines that are charged. You know, if there may be a criminal, a penal code law or something like that, you look at that and that'll give you a good idea of what's customary to charge a person for committing that offense. Only you're not in criminal law here, you're in common law. You understand there's three basic laws that we operate here is common law, civil law, which is the statutes, and penal law, which is also statutes or codes. But and then of course there's other systems like there's admiralty law and maritime law and so on. But basically you let him know that this is the cost of the damages. Damages means what's owed for the injury. That's item 5. I skipped 4, which is you let him know he's breaching his duty that you named in item 3. And then you demand that he get off your toe. Okay, that's number 6. You demand that he in good faith do his duty, pay you the damages, and to do so within a reasonable number of days, usually 60 days for government and 30 days for everyone else. But you make that demand, and this notice and demand could go to the risk management of a city, or it could go to the Court of Claims for the federal government. That's where you send your notice and demand. And you also, in number 7, you point out that if he does not do what you demand within the allotted time, then you'll take lawful action either in personam or in rem, in other words, either him personally or against his property, to defend yourself against him. Now this is an important point. You do not say to anybody, and you especially do not say it to public officials or judges, you do not say, do this or I'll sue you. Okay? Because that's a threat. Never threaten anybody. The concept is, if you're going to do something, do it. But don't threaten. Because if you threaten, that becomes, what's it called?
Assault.
No, not assault.
Actual.
No. No.
Trespassing.
No. You're saying,
A threat.
what does a person say when, yeah, it is a threat, but what do they call it now when you say to a person, pay me or I'll kidnap you?
Extortion.
Blackmail, extortion, there you go. You see that when you threaten a person, you're telling the person to do something or else. That's extortion. If you're going to punch somebody, punch them. Don't say I'm going to punch you if you don't do something. You see? Right. So, but what you can say, what you're entitled to say, is that if you don't quit doing what you're doing, I'm going to defend myself. Because that is a natural, universal right. Everybody has a right to defend himself against any unreasonable, unlawful attack. And so you treat this like he's attacking you. You never say to the person, I'll sue you if you don't quit attacking me. Never. You always say, you either quit attacking me or else I'm going to start defending myself. That's acceptable. Here, in item 7, you say, if he does not do as demanded within the allotted time, then by tacit procuration, assumed power of attorney, you will determine for him the facts, his duties, and the damages he owes you. Tacit means that by the actions of the parties, you draw your conclusions as to what your relationship is. And what is that relationship? Well, procuration means you're going to be his attorney, his agent. So you will determine for him exactly what it is he was doing. You will become his representative. You know the old rule for courts. If you fail to object, it means you agree. You put in there, in this notice, that if he fails to respond to this thing, then you'll be his attorney. You'll make the determination for him. I love it when they throw these things away. Okay? What do you think the IRS does to people all the time? They send notices and a lot of people ignore them, right? Don't know how to answer them. They let the time go by. They go through the administrative process, get no luck there. They go to the court, and the judge looks at it, and everything is settled. Everything's admitted. All he does is apply the power of the court to what is already established. If you fail to object during the administrative process, then the court's going to look at that and say, well, look, you agreed this was so, even if it was by your lack of action, you agreed. And so you end up with the IRS orders being enforced in the courts. So never ignore notice. Never ignore anything that comes your way. You see the army, you're sitting in your castle, you look out the window and you see the approaching army, you go out and meet it. You don't wait until they arrive at the door. Okay? Okay, then finally the last one is, if he does not perform as demanded, you will take lawful action in personam and in rem to defend against him and all persons acting in concert with him, who cause or attempt to cause said injuries, to secure your substantive rights and to redeem the damages owed to you. So that's your constructive notice. So that precedes everything. Now, if somebody does something to you, sues you in court, you don't have to send them the demand anymore. Okay? Because they've already started the attack. Your answer is to counterattack. You do not give them a notice and give them more time. Okay? You don't allow them to build his strength up. So, you go ahead and you put together your counterattack. It's called a counterclaim. Okay? If somebody's attacking you. So, old rule in football. Best defense is a good offense. And it applies to court too. Alright. So that's the first step. Not yet. I'm going to put this on the internet in a few days. A couple days or so. Yeah. I just finished putting some of this stuff together last night. Yeah, this will be on the internet. Look in the procedure section and it'll be there. Now you're going to do a lawsuit.
Bill, I've got a question.
Sure.
If we're all sovereigns and we're foreign to the United States and the system, I went to a seminar about letters of rogatory. Do you have any comments about
letter
that?
rogatories? Yeah. Letter rogatory, all that is